I am sharing a split screen with a complaint filed a few years ago from the Manning law firm and signed by the lawyer Joseph Manning. And I think the issues named in this complaint are still relevant because we see them coming up over and over again by the most active plaintiffs' law firms. And the Manning law firm is out of California. And I'm going to go ahead and read off the accessibility issues named. The homepage has graphics, links, and buttons that are not labeled or are incorrectly labeled or lack alternative text. B, there are multiple unlabeled or mislabeled buttons and links. C, plaintiff encountered multiple pages containing insufficient navigational headings, which requiring plaintiff to expend substantial additional time to access information. D, plaintiff was unable to browse menu items because menu links and descriptions were inaccessible to screen reader technology. And E, plaintiff was unable to make a purchase because of an inaccessible checkout system. So you can see here, some of these accessibility issues are more vague than others, particularly the last one. Plaintiff was unable to make a purchase because of an inaccessible checkout system. Inaccessible how? What was it that was preventing a purchase? So what was it that you are claiming? What accessibility issue is being claimed that is preventing the purchase? But there were more specific issues claimed at the beginning. The Manning law firm is fairly active in this space. And so what I want to emphasize is that these accessibility issues are coming up over and over again from the most active plaintiffs' law firms. So throughout this mini-series, I've named several plaintiffs' law firms in New York and then Pacific Trial Attorneys in California, and now Manning Law Firm also in California. And we've gone through these complaints and we're seeing patterns come up. We are seeing the same accessibility issues coming up over and over again. So what that tells you is if you can remediate the issues that are most commonly claimed in litigation, you are going to significantly reduce your risk of receiving a demand letter or having a complaint filed against you. So this is it. This is what plaintiffs' law firms are looking for and claiming in litigation. So with this knowledge, you need to go and remediate your websites and eliminate these issues, because once you do, it is very unlikely that you are to have a demand letter or receive a demand letter or have a complaint filed against you. And this is why I created the ADA compliance course, because the lessons in that course are comprised of the issues that are being claimed over and over again. So in the course, I provide instructions on how to find the issues and then how to fix them. So this is the most effective way to significantly reduce your risk of litigation. Now, it's not going to cover every accessibility issue under the Web Content Accessibility Guidelines, but what it does do is it helps you prioritize the issues that are being most commonly claimed in litigation. And then once you have incorporated these accessibility measures to eliminate these different claims that are being made, then you can work down and work towards becoming fully WCAG conformant. But as it stands, you need to make sure that you have eliminated these issues that keep coming up in litigation, because as you lower the number of issues and the instances of those issues, you are going to dramatically decrease your risk of litigation.